I've understood you to say that you want access to the negotiations and the documents and everything that went on in the lead up to what would have been a plea deal that is approved by the court. And you say because you haven't had access to that, you're unable to get Mr. Matlala to respond to the notice that he has been given. Did I understand you correctly?
Indeed, because in that process that leads up, I'm sure, Commissioner, you've gone through those processes yourself. There's always deals that are made.
Your microphone is off.
Yeah.
Sorry, there's deals that's made. And that process to come to a finalization of a 105A involves a quid pro quo. And I need to see what the quid pro quo was.
But what does it have to do with the statement that must be submitted to the commission?
Because
let me finish my point. That process has concluded, even if what you refer to or what you describe as the quid pro quo were to be relevant to the answers in the statement to be submitted to the commission, which I'm not saying they are, even if they were to be relevant, that process has concluded, has been declared in accordance with the law to be null and void. So for all intents and purposes, it never happened. That's what that concept means. Why is that a hurdle to Mr. Matlala submitting his statement, answering specific questions that have been put to him, and you know that in answering those questions, he's entitled to say, I don't know anything about this, if he doesn't know anything about it, and the assumption that we must make is he's going to be truthful in his responses, and if he doesn't know, that's what it is. Why are the notes and the documents that comprise or that constitute what you say is the quid pro quo, why are they relevant for our purposes?
It's highly relevant because let's speculate. I don't want to go into this, but let's speculate for a second. In order for them to offer this deal, they sit around the table and they say to my client, we want information on A, B, C, and D. And A, B, C, and D forms part, let's say, of your list. But A, B, C, D is not part of the plea agreement. That is the deal that we cut here. You give us this information as an example, and we will continue, we will enter into this deal with you. So, for instance, if there is, let's say, a Section 205, Section 204 affidavit opposed to, I want to see that, because I want to see in that what transpired or what was admitted in that statement, number one. But number two, I want to see, and I feel very strongly about it, what transpired during these plea negotiations. Because in law, normally what happens, it's recorded. Because I have been quite vocal about the fact that, no, I'm trying to choose my words very carefully. The process that was followed, I've made it plain to you, I was not going to be involved in it because I didn't trust it. That's the 105A process. And subsequently, I'm even more concerned about the process that was followed.
I understand.
And what I'm saying to you then is, in that negotiations, names could have been mentioned, admissions could have been made, evidence he could have disclosed evidence to them. And I can't deal with it if I don't see what happened
that's
there.
information that's within Mr. Matlala's knowledge. I don't understand. I don't quarrel with you wanting to know for your purposes. For your purposes. I don't take issue with that. So you don't need to persuade me that you want to know, you're concerned about how that process was conducted. That's not the issue. The issue that I'm raising with you is specific questions were asked of Mr. Matlala to speak to in his statement. And those issues are the issues that have been identified as relevant to our terms of reference and for our purposes. What I do not understand from you is what is the problem or what is the hurdle to Mr. Matlala answering those questions if you do not know what happened in the negotiations? Because where I'm sitting, that negotiating process has nothing to do with us. it's completely irrelevant for purposes of the commission and getting the answers that we require from Mr. Matlala. Of course, we know that Mr. Matlala has the privilege to claim self-incrimination. I will not answer this question because it will incriminate me. I have a trial coming up. We have experience in this commission about that. People have appeared and raised that, right? And we abide the law when it comes to those issues. What I don't understand in the long engagement with the chairperson that you've had is why it is that until you have received the notes and have an understanding of what happened in the quid pro quo, or what it is that was given in a process that, by the way, is null and void as matters stand, we could never, as a commission, you know that, we could never make any reference whatsoever to what happened in that process, even if we had insight into it. We don't have insight into it. We don't know what was discussed. We don't know what documents were shared, what information was shared. But even if we knew that, we could never reference that, because that is an entirely separate process from our process, but that process is now null and void. So nothing that is said in that process comes before us by virtue of having been said in that process. If you accept that to be the correct position and the position of law, not just our conduct, but to be the correct position of law, you haven't said or explained why Mr. Matlala cannot submit his statement, answer the questions in whichever way he chooses, answer the questions asked of him until you've had insight into what happened between him and IDEC. The simple proposition being, he's been asked questions that are presumably within his personal knowledge, and he can give you instructions about those. And where he has no personal knowledge, he can say, I know nothing, and he'll come and tell us that. I don't understand the basis on which you are resisting. In fact, you say, I can never advise my client to answer questions. Well, it's for your client to make the decision whether to answer. Clients work on counsel's advice. It's not you who's answering questions. It's him who will tell you, this is what this question means. And you will say to him, well, that incriminates you. My advice is, you don't give them that answer because it incriminates you. It's ultimately up to him to make the decision, not for counsel to say you don't answer because it incriminates. So far, you haven't said to us, Mr. Matlala refuses to answer the questions that you have given to him. You haven't said that. Your case throughout is, I need to see what was discussed with IDEC, which I say, and I say it firmly, it's completely irrelevant for purposes of your postponement and for our purposes. You keep on saying that. But in fact, what you should be saying to us is Mr. Matlala refuses to submit a statement to the commission because of A, B, C, D. Then we deal with it on that basis. Thank you.
Commissioner, there's a few issues. The one thing that I've noted in the 10.6 that you, I assume, take quite seriously, there's a specific question that says, has any person tried to influence you, intimidate you, etc.? Now, you cannot say to me that that is not relevant to the Commission's work.
The answer can only be yes or no. And the rest would be the detail. If we are interested in a yes, if he says, yes, someone has tried to intimidate me, the Commission may well follow up when he presents evidence and say, well, give us the detail of that intimidation. But the answer is yes or no. There's nothing, there's no privilege about it. There's absolutely, and it's a matter that is within his personal knowledge. It doesn't depend on you seeing the documents from IDEC. It's an answer that Mr. Matlala is in a position to give to you. So it's a bad example that you're choosing.
No, I respectfully disagree with you, because if there are, if for instance there's intimidation, or for instance if there's undue influence, with the greatest respect, I've come across, and I've got no problem that you yourself have come across people that do not understand that what they are subjected to is undue influence to get to a point. So I stand by my answer previously. The other issue that I want to raise with you is, as a litigator, we've got ethical obligations when we deal with clients to ensure, and you're right, I advise my client. That is my duty. But I do not know of a single attorney or an advocate in this country that will allow their client to depose to an affidavit if they're not satisfied that what is in that affidavit is correct. We all do this. We do litigation, we run trials. That is our ethical obligation. And if the issue is then that I am obstructing the process, if I want to put obstructed in inverted commas, by insisting on making sure that what I have is correct, then blame me. Don't blame my client, because I believe that in acting as I am, I'm carrying out my ethical obligations. I've been doing this for long enough, so have you, to know things are not black and white. There's a vast grey area in between. And I want my client to come and assist the commission, but I want him at the end of the day to do so free of anybody coming and saying, you're committing perjury because we've got something to the contrary. I want him to come here without later on falling foul of a previous inconsistent statement. It's my job to make sure that that doesn't happen.
Can I ask you this question just to make sure that I understand your position? Is your position, and Mr. Matlala, when I say your, I really mean Mr. Matlala because he's the client, is your position that until you receive the material from IDEC that you say you need to see, what was given, what was offered, until you receive that, this commission will never receive a statement from Mr. Matlala and he will never testify? Is that what you're saying?
No, that's not what I said.
Then what is the relevance of the IDEC background material in a process that has been declared null and void?
Maybe I must just go one step further and say that I have discussed with my learned friend, and I actually didn't want to go there, that we can sit down at some stage and try and work out some of these issues. But I'm saying to the Commission that all we want is we want an opportunity to comply with the 10.6. I've never said we're not going to comply with that. We want an opportunity to do so. The second issue is, and I want to almost...
Sorry, what is the opportunity? I think...
I want to postpone it.
I want to make sure that we understand what it is you are seeking from us commissioners. When you say, you are not saying that until you've received the IDEC material, Mr. Matlala can never submit a statement and he can never testify. You're saying that's not your position.
My position is not, it doesn't only relate to IDEC. Can we just go one step further?
Let's take it one step.
It doesn't only, but let me just go. Yeah, it's on.
Thank you.
It goes further. The Commission is in possession of recordings that was only disclosed to us. So
no, hold on. I want us to do one step at a time so that we tick off what is the issue. If we've resolved an issue, we both agree this is off the table now. Now we are going to a different topic. I know that in your affidavit you do speak to recordings and transcripts. We will still get there. You haven't engaged with that. I just want to be clear, because my understanding from the time when you were engaging with the chairperson, and hence my questions that I've asked of you, my understanding of your position was, and still continues to be, that until you have received from IDEC, whenever that will be, if they will ever give you that material, until that point that you've received that material, Mr. Matlala can never depose to a statement, because you would not let your client depose to an affidavit where in future he gets met with previous inconsistent statements and all of that. So I ask the question so that there's absolute clarity about what it is that we are dealing with. Is your position, let me repeat, is the position that you are adopting that until you have received the IDEC material that led to the now collapsed plea deal, Mr. Matlala will not be in a position to file a statement to the Commission and Mr. Matlala is not in a position to testify before the commission.
Chairperson, of course, that is my position at this point in time, because I'm ethically bound to act in that manner. Again, I say to you, I cannot think of any other council that would act differently than I do. So, but
Yes.
This is not an impediment, because I truly believe we can get the information relatively quickly. So I'm saying to you, please just take into account, this plea deal collapsed on Monday. It's Wednesday. So we've got this very short period. But that's not the only thing that I say.
No, don't go to the other things.
Well.
I'm more interested in the question of principle. I want to establish the principle. It's important to us. If by the time we finish here, you rise and your position is until he has received the IDEC material, or you have received the IDEC material, whenever that will be, maybe tomorrow, maybe day after tomorrow, maybe next year, maybe not ever. I want to establish the principle, to make sure I understand the principal position. Is the principal position that until you have received and considered, as his counsel or his legal team, until you've received and considered the IDEC material, Mr. Matlala will not file a statement and he will not testify? Is that the position you are conveying to us?
Until such time I am told by any person in the legal profession that I'm wrong in going to a point where I say part of what I'm doing here is to protect my client's rights. I stand by that.
Yeah,
I
Miss-
say it is
I must insist, Ms. van der Heever, I've asked a direct question. Let's stop this going around. I'm not asking you about being advised by somebody, being told you're right or wrong. And I haven't yet expressed a view that you're wrong, by the way. I'm not saying your position is wrong, right? I'm still at the point where I want to understand the position. And it is a yes or no kind of question. You have motivated, you have argued, and you don't need to do that any further. I'm now at a point where I want to understand, is the position that until you have the IDEC material, Mr. Matlala will not file a statement and Mr. Matlala will not testify? The answer is a yes or no.
My instructions are that we will file a statement as soon as possible.
What is your answer to my question?
I've told you, Commissioner.
So you will file a statement even if you do not have the IDEC
That is
material?
my instructions at this
Okay,
point.
that you will file the
I got
statement.
instructions from my attorney to deal with it. in
Thank
that
you,
regard.
thank you.